Thank you for joining us in this webinar, in this joint meeting organized by the Brazilian Association of Financial Law, ABDF, and the Women of IFA Network branches Brazil and Mexico. On behalf of IFA Brazil and IFA Mexico, we are very glad to welcome you. And we have a very special topic today to discuss, the 15th anniversary of the tax treaty executed between Mexico and Brazil. And this date allows us to discuss a very important transformation that we have had in the last years regarding international taxation and interpretation of tax treaties. Today, we have a very special panel integrated by two great tax attorneys from Brazil and also from Mexico. Let's introduce them. Ana Carolina Monguilot. She is a director of the Brazilian Association of Financial Law, ABDF, and co-chair at the Brazilian section of the Women of IFA Network. She has an LLM degree in international tax law from the University of Leiden and a postgraduate degree in taxation from the Catholic University of Sao Paulo, founding member and coordinator of the Tax Policy Study Group, professor of tax law at INSPIR. Thank you, Ana Carolina, for being our speaker today. Ana Claudia Aki Utumi. She is a partner at Utumi Advogados, director of ABDF Brazilian IFA branch, and co-chair of the WIN. She is member of the NYU International Tax Programs Council, Women of IFA Network, Network Global Committee, IFA Permanent Scientific Committee from 2010 to 2017, and chair of the Brazilian branch of STEP. Welcome, Ana Claudia, and thank you for being our speaker today. From the side of Mexico, we have to Jimena Garcia Torres. She is a tax advisor with a broad experience in domestic and international clients. She has a tax degree by the ITAM in Mexico and an LLM by the LSE. She is a senior associate at Rich Muller Heder Nicolau. Thank you, Jimena, for being with us. And Stephanie Uribe, also from Mexico. Stephanie has a broad experience in domestic and international tax matters. She is a senior associate at Santa Marina and Esteta, SSE, an LLM by the Vienna University of Economics and Business Administration, and she is a tax lawyer from the Escuela Libre de Derecho. Thank you, Stephanie, for joining us. And let's start with the discussion of our topic today. On September 25th, 2003, Mexico and Brazil executed an international tax convention which entered into force in 2006. In 15 years, the international taxation has been transformed. The purpose of the tax treaties has changed, adding new priorities. Some traditional concepts have now a different meaning and context. The interpretation of the tribunals has also modified the scope of the agreements between the states, and some amendments in the domestic law have also impacted the construction and application of tax conventions. Today, we have the opportunity to hear those tax lawyers that I have already introduced to discuss how the international taxation has been transformed in the last 15 years, considering as example the case of the Mexico-Brazil Tax Convention. Thank you, and let's start with some questions about how this interpretation of the tax treaties has been transformed. Let's start with our first question for our panelists. How the purpose of the international tax conventions has been transformed in the last 15 years. Could you please, Ana Carolina, share some comments about your thoughts about this?
Of course, Fabiola, thank you so much. Thank you so much, IFA Mexico, Fabiola, Jimena, Stephanie. Thank you so much, IFA Brazil, Ana Claudia, for the invitation to join this so special event. It's really a pleasure to be here with you all. Hopefully, It will be the first of many other joint initiatives to come. And if anything good can be taken from these pandemic times, is the fact that somehow it increased the possibility for us to be together, even though virtually. So thank you so much. It's really great to be here. Regarding your question, Fabiola, it's a very important one. We should be constantly asking ourselves about it, especially now, I think. When I first started studying tax treaties more than 20 years ago, it was clear to me that among the several purposes a treaty could have, mitigating double taxation and fomenting cross-border transactions was the most important one. At that time, we, of course, had already taken into account harmful tax practices, harmful tax competition, tax shelters, but double taxation was still very important, if not the most important goal to achieve when you thought about a double taxation agreement. And as the years have passed, everyone will remember we are thinking a lot about the current crisis we are living, because we are living a health crisis, an economic crisis in many countries. But we should remember that the 2008 financial crisis was very important for all the countries and for our international tax policy formation. It seems that as the years have passed, this crisis we have lived, particularly in 2008, they have sort of changed the game, making the avoidance of double non-taxation much more important than other objectives. So as countries needed tax revenues, particularly due to the crisis, the global alignment shifted from avoiding double taxation to avoiding double non-taxation. And recognizing this fact now, I think that it's more important than ever. I believe that we will talk a little bit more about BEPS in a while, but BEPS is certainly something that came in this context. The idea behind Pillar 2 goes that way too. And now, in a COVID-19 context, when countries had to take extraordinary measures, not after losing, countries, they did not only lose tax revenues, but also had to face extraordinary and unexpected spending with health expenses and with relief programs. I think that the global goal of raising taxes more than, again, avoiding double taxation, it's getting more and more important. And we know that the US now is talking about a global minimum tax. And we are hearing now the US ambitious expanding plans. By a coincidence, tonight, President Biden will address the US Congress to detail his plans to increase spending and raise taxes. So I think that this is a bit scary. I know that revenues will be needed to face the times we're living, but we must be careful not to increase taxation too much, especially in countries such as Brazil, where taxes are already very high. Brazil has like an average global taxation as high as the average of OECD countries. So maybe, specifically in the context of tax treaties, maybe we should take one step back and increase our concerns with that old good goal of mitigating double taxation and boosting cross-border transactions rather than avoiding double non-taxation and increasing taxation just for the sake of doing so. Thank you, Fabiola.
Thank you, Ana Carolina. It's quite interesting to hear this summary of how the international taxation has been transformed in the last years. And in the context of the tax treaty, I think that we have some examples. Stephanie, what do you think? Do you think that this transformation has also, do you share the same thoughts of Ana Carolina regarding the international taxation transformation? Do you have any example with the international tax treaties that Mexico has executed, for example?
Yes, specifically, well, I really think that we have an example under the Mexico and Brazil tax treaty in specifically, well, the purpose of the tax treaty, which is to avoid double taxation, right? So, however, it is very interesting that in certain cases, any of the states of the governments sometimes does not reserve the right to tax certain income. So what will happen in these cases that it could lead to have a double non-taxation in certain cases, and only with the countries that reserve specifically the right to tax and the other don't, then under the domestic tax provisions, for example, one of them will say that I will not tax this. This will be considered as an exempt income, and then you will have a double non-taxation. For example, we can find this under the Article 11 of the tax treaty executed between Mexico and Brazil. We have an example specifically, for example, in the case of Brazilian government bonds. It is very interesting because, for example, in the case of the tax treaty, it is established that interest on public debt or on bonds or debentures that are issued by the government of Brazil shall only be taxable in Brazil. So Mexico here does not reserve the right to tax the interest arising from this bond. In it, therefore, you can interpret or you can apply this specific tax treaty as establishing that the interest should be exempt, and therefore that Mexico does not have the right to tax it under the Mexican law. So here that you don't have to accrue the interest that arises from these bonds, which can lead to certain impact because at this moment specifically, you can have an impact on the distribution of the dividends in the later, because as you didn't consider that they were taxed under the domestic law, then you can end paying a more expensive tax in later when you try to distribute these dividends, because we have certain tax rules that will trigger these. And also you can have a certain impact on the deductions received from this interest, and therefore you will have a more complicated issues for treating this income as exempt under the tax treaty, and therefore instead of having a benefit, then you will have a more complicated, a more expensive income rather than you will have a benefit under the tax treaty. So, well, in this case, therefore you can instead of having an incentive, then you will have a more expensive transaction, which actually is I really don't think that was the intention of the parties by exempting this. But under our domestic laws, then you will have to interpret this and then determine if it's better just to apply an incentive under or a benefit under the tax treaty, because maybe under the domestic laws you will end paying more, which is why this is a very interesting example. Also, well, we have some domestic measures which are actually in the context of this evolution from the OECD measures. And we have, in our domestic law, you actually have to prove that in the other country is actually subject to tax in order to apply the tax treaty. So with these domestic measures, then the question arises if you can have a treaty override or not. But the thing is that at the end, these domestic measures, in my opinion, end by being in the context of the tax treaty, because the purpose or the intention is to have to avoid double taxation and not a double non-taxation, which is the purpose of the treaty. So what do you think? What do you think this is? If it's a treaty override, or is something that is actually in the context and should be interpreted like that as a domestic measure?
Thank you, Stephanie. I think that the question is quite interesting, and maybe we could have some minutes at the end of the session also to hear our participants, because, well, for example, the Mexico-Brazil Tax Convention has 15 years, and we have other tax treaties. I mean, Mexico has other tax treaties with 20 years or 25 years of existence. However, we see that the domestic laws and also the interpretation of the tribunals have had a different purpose in tax treaties, and also in the impact of the context to apply the benefits of the tax treaties. And sometimes, as you said, the effects affect the taxpayer when you see the context of the transaction in a general manner, not only in the context of the benefits of the tax treaty. And I think that this is very connected with the discussion that we have had in the last years regarding BEPS. Mexico is a member of the OECD, as Stephanie already said, and Mexico has been incorporated many measures that are being recommended by the OECD. Brazil is not a member of the OECD, but I think that now all the countries are part of this BEPS discussion and these BEPS measures that we are implementing. It doesn't matter that if we are or not members of the OECD. And I think that this is the perfect link for our second question. Let's go to it. How BEPS has transformed the interpretation of the tax treaties? Do you see any evidence of such transformation in the context of the Mexico-Brazil Tax Convention? Ana Claudia, what do you think?
Thank you, Fabiola, for this opportunity, and thank you for helping to organize this panel. Before going into specific detail on this, just remember that Brazil has the status of associate to a number of the OECD initiatives, including the initiative of BEPS. And in BEPS, Brazil is part of the steering group of the inclusive framework. So Brazil is highly engaged in the BEPS discussion, even though our process of accession to the OECD has not started yet. It has been requested years ago, but up to now, we haven't had the starting point of our accession process. And when we have the start of the accession process, you from Mexico know well that this is not something that happens from one day to the other. It will take some years for Brazil to be admitted if we have the start of this accession process that we haven't had yet. In relation to treaties and including Brazil-Mexico treaty, what I see of one of the main consequences of BEPS was to enhance the collaboration among tax authorities of various countries. And as a result of this collaboration, we have tax authorities of different countries speaking among themselves more than ever on various subjects, including the application of tax treaties. And we saw not only the advances of the Action 6 report, but actual implementation of measures with the MLI. The MLI is the point that Brazil has not signed the MLI. There is no intention for the time being to be a signatory. So, but on the other hand, Brazil committed to adopt all BEPS minimum standards, and the points included in the MLI are part of the BEPS minimum standards. So Brazil has started efforts to renegotiate the treaties and renegotiate treaties to contemplate MLI-like standards. So we are not signing the MLI, but Brazil is renegotiating treaty by treaty. We have already concluded renegotiation with Argentina and with Sweden, but there are many other treaties to be renegotiated. So it will take much more time for Brazil to actually implement the recommendations of BEPS 6. And if we look at Brazil-Mexico treaty, we have anti-abuse provision, and anti-abuse provision saying that the tax authorities may deny the benefits of a treaty, but this denial cannot be just unilateral. It has to be under a mutual agreement procedure. So for both authorities to be convinced that there is an abuse of the convention and not simply one state, one country unilaterally disregarding the use of the treaty. So the Article 20, and it's also interesting that if we look at the MLI on the principal purpose test, that is one of the manners of controlling the abuse of treaties that is contemplated in the MLI says that, well, that the principal purpose test, that when the tax authorities analyze, after analyzing all facts and circumstances, conclude say that it's reasonable to conclude that the main purpose of a certain situation was to save taxes based on the treaty, or the main purpose or one of the main purpose. And the Brazil-Mexico treaty has a definition. I believe that it's broader than that, because they say the competent authorities may deny the benefits of the convention under article after the mutual agreement procedure to any person or in relation to any operation if, in their opinion, the granted convention benefits constitute an abuse. So it says just their opinion. They don't go deeper on what MLI says of analyzing all facts and circumstances. So, and this is concerning in relation to Brazil, because Brazil has adopted along the years a very broad definition of abuse. Instead of having a specific anti-abuse clause or a general anti-avoidance rule, what Brazil is doing is applying the concept of abuse from the civil code that is so broad that when someone does anything against what is considered that it's a good manner it can be considered abusive. So it's not abuse against a law, but it can be abuse against a law, against abuse against the purpose of the law, of the economic objective of the law, of the social objective of the law, and against good manners. So it's very, very broad. And the concern of having a clause broader than what is even the MLI says is that there is a number of multinational groups, Mexican multinational groups operating in Brazil that are struggled in a number of tax litigations against the tax authorities, exactly because of this broad scope of what is abuse for Brazilian tax purpose. And so, we see cases in which there is a denial of a certain treaty, benefit based not on the argument, not on the treaty, but on the argument of abuse. So the same thing that you discussed, that sometimes you see the authorities to unilaterally adopting measures unilaterally to avoid abuses, we are seeing here in Brazil as well.
Thank you, Ana Claudia. And at the end, the concept of abuse has been there for many years. I think that the problem is that our interpretation of what is an abuse and the cases that may produce abuse is what is changing. And I think that this change in the interpretation of the concepts derives also from what we are seeing in the international context, what we are discussing internationally. So maybe the concept is not directly taken from the MLI, is not taken directly from the commentaries from the OECD. You have a broad concept, but now the interpretation of the concept is also being affected by what is discussed internationally. And Jimena, what do you think? Do you have any specific example of transformation in the case of any concept of the tax treaty executed between Mexico and Brazil?
Sure. Thank you, Ana Claudia. Thank you, Fabiola, Ana Carolina, Stephanie. I think I've been listening to what Ana Claudia was saying. I think in the case of Mexico, we are taking baby steps against tax avoidance. We just have a very recent incorporation of a GAR rule and reportable schemes. So Ana Claudia, definitely from a Brazil standpoint, it's very different from Mexico. But I think we have a very close example with regarding to the permanent establishment concept. And I'm going to try to be very brief because it's clearly it's a robust concept in the international tax theory and in cross-border transactions. But in benefit to all the people that are listening to us, and especially if they're students, the permanent establishment concept, the PE concept, it is a key definition, and it's establishing a minimum threshold for source taxation. So every domestic tax law incorporates the concept of what is a PE. Brazilian income tax law do it, the Mexican income tax law do it, and of course, as based on the OECD model and the UN model, we have the same incorporation or the same definition of a PE within our double tax treaty, specifically in Article 5. But the transformation here comes when it is to my understanding that in Brazil, the concept of a permanent establishment, it is very close to what is written in the double tax treaty, which basically parts from two main concepts. If you have a fixed place of business that is in the disposition of the foreign resident, or if you have a dependent agent that is carrying business activities in favor of the foreign resident in the source country. That is the most well accepted and commented definition of permanent establishment, as well as with the exception of what it cannot be understood as a permanent establishment, and those are the preparatory and auxiliary activities. The issue here with Mexico is that we adopted in 2019 the new definition of what it has to be understood for a PE. And this definition, it was not created solely by Mexico. It is completely taken by Action 7 of the PEPS project, which were international measures signed by the Inclusive Framework and by the G20 in order to stop the avoidance activities for many multinationals. I don't want to set a specific example, but I think it would be very useful if we talk about a little bit of, in order to understand which type of abuse of a permanent establishment carrying on the multinationals. I think we're all very familiarized with a company that started with an A and it has like a happy face logo. Well, this is the typical or stereotypical example of abusing a PE. A company that it's locating storages, bodegas, or any other places that turn to be auxiliary in source countries, and it is certain that source countries usually are poor countries, so you have, or more poor countries, and they benefit for that, like China, India, Latin American countries, Mexico, and they start fragmenting their activities in order to not create a permanent establishment, but actually conducting their whole businesses throughout this fragmentation. So based on this abuse, the Mexican Congress decided to modify the Mexican income tax law, specifically Articles 2 and 3, in order to ring-fence the concept of PE. So what I'm trying to go here is that we have a mismatch in what in the Brazilian income tax law, in the Mexico-Brazilian double tax treaty, and in the Mexican income tax law. And I know many practitioners, very serious practitioners, maybe they would say, okay, but we have to reserve the definition that was established in the model tax treaty, because it was agreed between two countries, and you have an international commitment to respect what was established in the double tax treaty, and to only try to use it for the cross-border transactions. I'm struggling to go with that conclusion, because I think it is obvious that the Mexican tax authorities and the tax courts, they have been more active in taking other type of interpretation and definitions of what is in the law and what is in the double tax treaty. I think from a SAT point, which I think SAT is the Mexican version of the RBF, they wouldn't agree with this definition, and they would try to utilize what it's written in our new version of Article 2 and 3 of our Mexican income tax law to decide whether if you have a PE exposure. So the message of this analysis is, if you are a tax practitioner, a Brazilian tax practitioner, or a Brazilian businessman, and you are conducting activities in Mexico that you believe are being carried by an independent agent or by a dependent agent, but that do not create a PE exposure, or you are only doing auxiliary activities, we would truly recommend you, if you could go with a Mexican tax advisor and actually analyze if there is any possible liability that you can have. Because the Mexican tax authorities may not agree with your interpretation of the tax treaty. And this goes beyond the tax implications. You're actually affecting investment, and you're actually creating a very undesirable uncertainty level on how it's going to act the local tax authorities regarding a concept that should be respected. So I think that would be.
Jimena, we had some problems to hear you at the end. Not properly.
Can you hear me now?
Yes, perfect.
Okay. So maybe the SAT, they were trying to intervene my line, so I don't speak against them. I'm sorry. I hope it doesn't happen again. But that would be my standpoint to this issue.
Thank you, Jimena. I think that the PE concept has been one of the most problematic concepts for international taxation, and it has been in the focus of the attention of everybody in the last years. But I think that there are many concepts that are now with a lack of congruency. And I think that we can see a concept in the tax treaties, as you already described in the case of the Mexico-Brazil Tax Convention, and we could have a different concept for domestic purposes. And now, for example, in the case of the PE concept, we have a different concept in the MLI, which has been executed by Mexico. So we have a lack of congruency in general with respect to the concepts, to some concepts. And I think that this is an issue that is linked with our third question. One of the most important features in the Mexico-Brazil Tax Convention is the concept of royalties. It is quite interesting how the authorities and tribunals of both countries, Brazil and Mexico, have interpreted the scope of the royalties concept and its interaction with the business profits clause. Ana Claudia, could you please describe which is the problem regarding royalties and business profits, why this is an important topic for our tax convention?
I think it's Ana Carolina first.
I'm sorry. Thank you, Ana Claudia. Ana Carolina first, please.
Thank you so much, Fabiola. Yeah, that's a very interesting discussion, as well as the DP discussion that Ximena just touched. It's very interesting. If we have the time afterwards to talk a little bit about how Brazil deals with it. And Brazil always has a funny manner of dealing with taxation, and that's kind of what happens here with royalties in connection with technical services. But before we go into the definition of royalties, I wanted to cover a few general concepts. And as Ana Claudia just mentioned, Brazil wants to become, but it's not an OECD member yet. And we have formalized our wish to become a member in 2017. But we are not quite there yet. And as Ana just mentioned, we have not even been accepted as a formal candidate. So no accession roadmap has yet been traced. But historically, Brazil claims many of its international tax policies are aligned with the OECD. Maybe not in the field of transfer pricing, and we are working on that. And the Brazilian tax authorities are carrying out a very interesting work with the OECD in order to seek alignment. But in other areas, usually the Brazilian tax authorities claim that we do follow OECD standards and concepts in general. And but Brazil is not bound by the OECD standards. And even though it constantly claims that our treaties follow the OECD Model Convention. But let's see. I think that in broad lines, like broadly, our treaties do follow the OECD Model Convention in respect of Article 7, I think so. It's basically what we have there is what you would find in the OECD Model Convention. But our tax treaties, they substantially deviate from the OECD Model Convention in its Article 12, which is relevant for royalties, and in Article 21, which is relevant for other income, reminding us that maybe in these aspects, maybe Brazil, it's closer to the UN model than it is closer to the OECD model. Our treaties generally allow source taxation under Articles 12 and Article 21. So besides that, under Article 12, which deals with royalties, most Brazilian treaties include in the definition of royalties, technical assistance and technical services, usually without giving any specific definition to them. And that's why someone could claim that Brazil has sort of its own model convention, as a few other countries do, because our conventions are quite peculiar. But summarizing a very long story, more than 20 years ago, the Brazilian tax authorities interpreted Article 7 as not including any sort of services. Since services fees were, when they are paid abroad, they would not correspond to business profits as defined under Brazilian law, because under Brazilian law, business profits would be a net amount, allowing deductions to be taken from gross revenues. And since service fees would characterize a gross payment, it could not, in their view, characterize a profit. Their focus was mostly on service fees not involving transfer of technology. And because I think that service fees involving transfer of technology, it would be more obvious for those services to be under Article 12, in which Brazil can impose its source taxation. So in 2012, we had a very important ruling from our second highest court, o Superior Tribunal de Justiça, STJ, which is second only to our Supreme Court, which deals only with constitutional matters. And the STJ, this court, took the stand that the interpretation given by the tax authorities to Article 7 was wrong, because we should accept that service fees are covered by Article 7. So it would prevent Brazil from taxing them when service fees are paid abroad. And in 2013, reacting to this ruling and to a certain amount of international pressure, the National Treasury Attorney General Office, Procuradoria, issued an opinion explaining that excluding services from Article 7 would be the most proper interpretation to be given to a tax treaty. And it's interesting that the Attorney General Office again seemed to put a certain focus on technical services that do not involve a transfer of technology. So I'm just trying to show here that this difference between services, technical services that involve a transfer of technology and that do not involve a transfer of technology was not a difference that was made up by tax lawyers. This is something that the Brazilian tax authorities and that the Attorney General Office keep bringing up. So in 2014, the Brazilian tax authorities formally changed their prior opinion, admitting that service fees may characterize business profits under Article 7, but only if they do not fall under Article 14, the independent personal service article. Yes, we still use it in a lot. And that provided also that these services are not equated to royalties under Article 12, whether or not, and it expressly states that whether or not these services involve a transfer of technology. Also in 2014, our Federal Revenue Service issued a normative ruling defining technical services and technical assistance for domestic purpose. And the definition goes sort of as follows, that technical service is a service that relies on specialized technical knowledge or involves administrative assistance or consulting carried out by independent professionals or employees. So it's in essence, it would be a service that requires specialized technical knowledge. Such a broad definition for technical services that has also been applied to tax treaties basically takes almost every service out of the scope of Article 7. If it's like, please tell me what does not require a specialized technical knowledge, especially when we are talking about cross-border transactions. It's like I find it very unlikely for a Mexican company to come to Brazil to hire something that does not involve some sort of specialized technical knowledge. It's like you are not coming here to hire like very simple services. It wouldn't make sense. So if this definition, this domestic law definition in my mind is applied in a treaty context, it's like everything will be taken out of Article 7 and we will basically apply Article 12 for everything, and Brazil will be allowed to impose its withholding income tax. One good news is that recently in 2017, an advanced ruling was issued by the Brazilian tax authorities, recognizing that the intermediation services do not characterize technical services under the Brazilian-Mexican Treaty, therefore not being subject to withholding income tax in Brazil due to the application of Article 7. And even more recently, in 2020 and in 2021, STJ, that very important court of ours, reviewed interesting cases and laid down very interesting rulings, frequently mentioning the OECD, to the point of, and that's really interesting, to the point of reproducing the notion that treaties are not only meant to avoid double taxation, but they are also meant to avoid double non-taxation. Particularly in one ruling, it emphasized the need to verify if a certain service characterizes or not a technical service. So in this case, they just send the case back to the lower court for this lower court to verify if this service would characterize a royalty or not. So things are bad in Brazil. This sort of funny interpretation that we used to adopt, that Article 7 does not cover any type of service, this funny interpretation is not adopted anymore, any longer, but defining technical services, it's still a challenge. And it is a very open challenge yet. In my mind, the issue is not settled. So I believe that interpreting technical services along with the context of the treaty requires these services to somehow have a connection with the other events that usually characterize a royalty payment. That is, the context of the treaty requires that. We know that when a treaty does not define something, the country applying the treaty may use a domestic definition as long as the treaty context allows it. So very quick 5 last points for our reflection before I finish. First point I wanted to make is we all know that the UN Model Convention has adopted since 2017 an Article 12A exactly to deal with fees for technical services. And they have defined these technical services under the UN Model Convention as payments for services of managerial, technical, or consultancy nature. Very broad, very open to further debate. Some will say that the term technical services should be actually interpreted as services without disregarding the technical, because everything is technical at the end of the day. Some may even try to apply the same rationale to Brazilian treaties, saying that everything is technical. So let's just accept the fact that everything is under Article 12. But I would raise the following question. If technical services are just regular services, being possible to adopt this interpretation regarding Brazilian treaties, why is that the UN Model Convention found it necessary to create a new article to deal with it, instead of just making an alternative wording for Article 12? I ask myself that because maybe the reason, the motive they found to create a new article under their model convention is exactly the fact that if they had it under Article 12, the context of the treaty would limit the concept of technical services. So that's why they had to draw a new article, a completely new article for that. Because when you have technical services inside Article 12 dealing with royalties, the context will limit its meaning. In 2006, the Brazilian tax, a second point. In 2006, the Brazilian tax authorities issued an administrative act just to clarify for the purpose of the Brazilian-Spanish treaty, that Article 12 covers technical services, whether or not they involve a transfer of technology. So why was this clarification needed? In 2017, the protocol to the treaty, to the Brazilian and Argentine treaty was changed to include a definition of technical services and assistance. Why this was needed? And finally, the treaty between Brazil and Mexico has given no definition to technical services, right? So I would love to hear Stephanie and Ximena on how they believe Mexico would interpret it. A mismatch would take us to a bad outcome, as Ana Claudia will soon detail to us, the bad outcome that interpretation mismatches may take us. And you asked us about, Ximena, you asked us about the risk of someone saying that maybe Mexico is overriding the treaty. I think that maybe we have the same risk here of Brazil overriding our treaty due to our very peculiar interpretations, the interpretations we give to treaty concepts and when we apply and interpret treaties. And lastly, the very last point regarding the Brazilian-Mexican treaty. We have a wording there that it's a most favored nation clause under the Brazilian-Mexican treaty that seems to put aside this treatment, the inclusion of technical services in the definition of royalties in case Brazil does that in any other of its treaties. So I don't know if Brazil will ever accept technical services not to be taxed as royalties under its treaties. Probably not, because Brazilian tax authorities, they really make a big effort to make sure all of our treaties have it there. But maybe we should follow it this closely. And it's very interesting. I don't remember seeing that in any other treaty that Brazil has signed. And it maybe indicates that the Mexican authorities, they were not really comfortable with this treatment that was given to technical services under the Brazilian-Mexican treaty, and that's why they negotiated a most favorable favored nation clause to have it there. And that's it. Thank you, guys. I'm sorry if I spoke too much.
No, thank you, Ana Carolina. I think that all your comments were quite interesting and opens perfectly the discussion of this point that clearly is one of the most important problematic aspects of the tax treaty between Mexico and Brazil. And the peculiarities are not only from the Brazilian side. Mexico has its own peculiarities. And I would ask Stephanie and Ximena to summarize some of the peculiarity and the different interpretation that we are having for Mexican purposes. Stephanie, could you please start maybe with the concept of royalties, please?
Sure. Well, specifically, it is, well, taking into consideration what already has been mentioned, it is very interesting because the concept of royalties in the tax treaty, actually, if you review it in first instance, does not include the term of technical assistance, but the term is included in the protocol. So what does this mean is that at the beginning, it was not clear that actually the technical assistance services should be included here. So this is very interesting because you can see how it actually evolved the definition and they just included the technical assistance term there. However, this is very interesting for us because actually we don't include this type of technical assistance on our royalties definition. Under the Mexican tax law, actually a technical assistance payments are those that are not considered as royalties and should be understood as the rendering of independent personal services in which the service provider is obliged to provide non-patentable knowledge. That does not imply actually the transmission of confidential information related to industrial, commercial, or scientific experiences, where the service provider binds itself to be involved in the application of such knowledge. So what you are actually, where you were referring with the transfer of technological services or those, it actually makes sense with the definition or the concepts that are used by the OECD when they are treating, for example, know-how services, where actually it is involved the transmission or of certain confidential information in the provision of those services. And that is actually what makes it very interesting. So this may be this interpretation and this definition, it may be in contrast our domestic law, which actually the definition of the Brazilian Mexico tax treaty, because here what you have is certain services that says that are not considered as royalties, but then you have a discrepancy under the tax treaty which says that actually technical services should be treated as royalties. So here we have a very interesting analysis that we have to develop, because for us in Mexican laws, our tax treaties has a higher, or where it has been this resolved that the tax treaties has a higher level that rather than our domestic law. So here it would be interesting to determine which actually would be the concept that actually would prevail, because also we have another interesting case under our domestic laws, where even the tax court has not determined that our technical services fall even under Article 12 or 7. They say that they are not even covered by such definitions, because actually they should be treated as they does not fall under Article 7, because our Mexican tax courts are saying that the technical services are not entrepreneurial activities and therefore should not be covered also by Article 7. So maybe this is very interesting to see this perspective, because actually Mexico even has not included the definition of technical assistance in other treaties. For example, we have the tax treaty executed with the United Kingdom, and actually technical services is not included under the definition of royalties, because even it does not make sense with our domestic law. So maybe Jimena, she can also cover more what the Mexican courts have pronounced with regard to these services, and give another perspective and another example with regard to this is very interesting analysis.
Thank you, Stephanie. Jimena, yes, the problem doesn't finish with the concept of royalties. In Mexico, we have a very peculiar interpretation of what is business profits. Could you please share your comments on this regard, please?
Sure. As Stephanie was mentioned, the position between the Mexican Federal Tax Court and our Supreme Court has been an on and off relationship in trying to define what it has to do with business profit. It's not as broad as you're saying, okay, so business profit has to be this. It's based on specific examples. And we have one regarding advertising that it has been in the center of the tax discussions for many, many years. So I'm sorry that we don't have a specific case between the Mexico and Brazilian double tax treaty. And if we do, please correct me, Fabiola and Stephanie. But in my experience, it has been based more on the US and the Mexico double tax treaty. It makes sense because it still is our main commercial partner, and many of the litigations originates in this double tax treaty with similar to the Brazilian, it's pretty complex. And there are many things that you have to take into account. But the last year, we have a case regarding advertising in which the Mexican Federal Tax Court decided that advertising was actually could not be understood as a business profit. And they gave two main arguments, which I do not agree with them. The first one is that in the text, within the definitions of double tax treaty, you cannot actually find the word advertising, which I think, oh, okay, like I can see what they're trying to get to, but it would be an incomplete interpretation. And the second one is that if you go to our domestic laws, specifically the commercial code, and I want to stop myself just like 15 seconds to give you the context of this law. This is a very, very ancient law. And when I say ancient, I'm saying the 19th century. Like we didn't even have the OECD or the UN or any business model that we have today. Maybe it couldn't be considered in that law. And it hasn't been a law that it's been changing with time. It has prevailed very similar to the same form it was enacted. So the court said, okay, so you don't have it within the text of the tax model and you don't have it within your domestic law. So, I'm sorry, so it cannot be understood as business profit. And just as a coincidence, we have it as a similar concept in our Mexican income tax law, and we can have the taxing right. So we may withhold you a certain % of that business profit. Again, they're trying to make a treaty overriding. They're trying to create a very limited interpretation in favor of the tax authorities. This case has been very problematic, even to the point that our Mexican tax ombudsman, and I think it was a good decision, they made a recommendation in a previous case that's similar, that the Mexican tax authorities and the courts, both at the federal level, just for taxation, and the upper instances, they have to respect what was agreed in the model. Because what you have in a convention is, again, an international commitment. I can understand that maybe the Mexican tax authorities, they consider there been an abuse from taxpayers, once more about multinationals, but that shouldn't be the reason for denying what is really the right interpretation of a model, of a convention, that you agreed during the last decade and the decade before. Mexico made a serious effort to celebrate many of their tax treaties. And now we have another different scenario where the Mexican tax authorities and our representations for international matters, they are not willing to modify their bilateral conventions. They're very keen to include the modification based on the MLI, on our domestic law derived from the BEPS, but it is needed to have a change within the bilateral tax treaties, and we don't have it. And I just like to close this participation saying that Ana Carolina was mentioning that in Brazil, you usually can have a tax ruling, or maybe the tax authorities, they just publish a tax ruling. In Mexico, it's different. You as a taxpayer, you can go and request to have a tax ruling to say like, okay, I think my position regarding this tax treatment is A. Please confirm if this is correct. And maybe you will receive a response from tax authorities, but it's not binding and it's not mandatory for neither party. So you just have a written position from the tax authorities that you might not use in the future. In a practical view, I am no longer certain how useful can be to have a tax ruling. And there are even other taxpayers and tax advisors that they say, you know what, please don't go with a tax ruling, because you're even telling your position. Like if this would be a war, you're giving a strategy to tax authorities that what you're gonna do. So you're coming with a blank page saying what you're gonna do. And it's not gonna work in benefit of the interpretation of a tax treaty. I think in order to not overstep the time of Ana Claudia, that would be my position about this question.
Thank you, Jimena. Thank you for summarizing all these criteria that we are having from the Mexican tribunals and that are being very problematic. But as all the discussions, the problem is not only technical and it's not only theoretical. We have many examples of what are the consequences of having this lack of congruency with the concepts and the interpretation of the concepts in a tax treaty. And I would ask Ana Claudia to present a case that was in the context of the Mexico-Brazil Tax Convention regarding these problematic concepts of royalties and business profits. Please, Ana Claudia.
Thank you, Fabiola. In fact, this is a very interesting and this is a subject that concerns, I think, many of the multinational groups that operate in Mexico and in Brazil. And the case that I faced with a Brazilian subsidiary of a Mexican group, and the subsidiary was paying services to the parent company, and corporate services such as administrative support, marketing strategy, financial analysis. So there were no technical services, but let's say, quote unquote, day by day corporate services that is common in all or in most of the multinational group. And the Mexican company and the council of the Mexican company understood that this payment would clearly be subject to the Article 7 of the treaty. And we totally agreed with this interpretation because of the description of the services. The problem was the following. When any company in Brazil will make a transfer to abroad, it's mandatory to perform this transfer through one of the banks authorized by the central bank to operate with foreign exchange. And when the company got to the bank to make the remittance, the bank said, look, because I'm as a bank, I'm co-responsible for any taxes due in a transaction because of the regulation of the central bank. It's not a tax regulation that makes banks jointly liable, but rather a central bank regulation. And because the tax authorities have a much broader interpretation on what technical services are, I will only let you make this transfer if you show me the receipt of withholding tax. So we engaged in a discussion with the legal area of the bank, showing that, look, we have the Superior Court of Justice decision. We have here the contract showing that it's day-by-day services. And it's clearly, we have the opinion of the Mexican Council that from a Mexican perspective, it is Article 7. We have all the arguments here. But then the bank, in the end of the day, the bank said, okay, so if you want us to make this remittance without withholding tax, you go to the tax authorities, present a formal consultation. And when you get the answer, if you get a positive answer from the tax authorities, I will let you transfer with no withholding tax. Well, first of all, formal consultations here take a long time to be answered because all the formal consultations nowadays, they go to the central office of the federal tax authorities in Brasilia, and they are the ones who answer. So it may take 8 months, a year, 2 years. There are certain cases that took 3 years for the tax authorities to answer. So there is no way to predict. Secondly, several times that they were consulted on the subject, the answer was that, well, this is actually technical service. So as Ana Carolina mentioned, the concept of technical service is so broad that you don't hire anyone to repair anything in your home if you don't have the person with the proper skills. So everything is technical service under the eyes of the tax authorities. So the Mexican group decided not to present this formal consultation and proceed with the transfer without the consultation, so paying withholding tax in Brazil. So they had to pay 15% withholding tax in Brazil, in addition to a number of taxes, because when we pay services to abroad, we have to pay, in fact, we have to pay withholding income tax, withholding service tax, two social contributions on services, one special tax on services, and we have to pay the tax on foreign exchange transactions. So in one payment of services, we have 6 different taxes, and so withholding tax was one of them, but 15% that grossed up is 17.7%. So it's significant, it's not irrelevant. But this Mexican group did not take the tax credit in Mexico because they understood that if they were to take the credit in Mexico, they would probably start a discussion with the Mexican tax authorities, because it was a situation that was clearly non-technical services, but being applied this broader concept of technical services and making an income from Article 7 being subject to Article 12. So because of that, the Mexican group decided not to move ahead with the tax credit. So in the end of the day, there was actual double taxation, because there was 15% taxation here, and this income was included in full in the taxable results of the Mexican company. So this is something that is quite common in terms of types of services that was involved in this case. Thank you, Fabiola.
Thank you, Ana Claudia. I think that you described perfectly the case law, and which is the essence of the problem here. You have a broad concept of technical services, and we have a very peculiar clause regarding royalties in the tax treaty. And on the other side, in Mexico, we have a very restricted concept of business profits. So I think that we have the perfect mix to have these kind of problems in the context of our companies and the individuals that have international or Brazilian, Mexican transactions. But I would like to give the floor to some of our participants. I don't know if there is any question or comment, if you could take advantage of having these extraordinary panelists today. If you have any question or if you want to share any comment, please feel free to raise your hand. We can see you and we will turn on your microphone, or read also your questions in the window chat.
In case there is no questions from our, Fabiola, hi?
No, I think that we don't have more questions, but I would like, yes, Ana Carolina, please.
I had a question for Stephanie and Jimena, which would be the following, and it would be, this question would be connected to the case Ana Claudia just presented. Because if I understood correctly, the interpretation that you have been internally given to technical services is that it would not fall under Article 7, because it would not be correspond to income from an enterprise, from a business, right? So I was wondering whether when we have deals between Brazil and Mexico, if it isn't better just to try to characterize the service as a technical service, because I'm curious about the outcome of it, because if Brazil interprets thinks that a certain service is a technical service and that Brazil may withhold its income tax, and if I going to Mexico, if I try to fight it by saying that it is business income, I will not get I wouldn't get a credit in Mexico, right? As Ana Claudia just described. But if I admit in Mexico that what we have here is a technical service, if I understood correctly, you would also accept that it falls out of Article 7. So how would we treat it? Would we accept that Brazil could tax it? And then would Mexico, if I do admit that it is a technical service, would you accept it as something that could be taxed in Brazil? And would you give the credit? I'm just curious about how we could avoid the outcome Ana Claudia just described.
Well, in my opinion, I would say that actually, well, the conservative approach would be that you would treat it as a royalty, and therefore that it would be subject to tax to the reduced tax to 10%, because I understand that Brazil has a most favored nation clause, so it would apply the 10% in my perspective. So because even though that you have another definition on our domestic law, the way that we should interpret it is, if you have the definition under the treaty, then you should attend the context of the treaty. Therefore, I really think that would be very unlikely to have a favorable resolution in connection to discuss this as a business profit, because even in our domestic, in our tax, we have a tax court resolution that says the other thing that we already mentioned, that that technical services are not business profits. So actually you will have that. So the most conservative and recommendable approach, in order not to have a problem here and you will able to create this, it will treat it as a royalty income. This is in my opinion. I don't know, what do you think, Jimena?
Yeah, I agree with Stephanie's position. I think it would be 10% because of the most favorable clause, and also because the position of the SAT is always, or in my experience, what I have seen is like, so if you're actually applying a withholding and if it's being taxed, that's better than if you try just to not give them any taxation right. That's when you put yourself in the spot. And in practice, it's a very common, not only for royalties or technical assistance or advertising, as I was saying, for business profit, but in doubt, what the SAT prefer is that you tax it. And I think it's what I conclude about that point.
Thank you, Jimena. Do you have any other comment, or could we close this session? No? Our panelists, do you have any other comment? Our participants, do you have any question? Okay. Anyway, you can see the video of this session. We will share in the chat window the link where you can find the video. And thank you very much on behalf of the ABDF, on behalf of IFA Mexico, IFA Brazil, the Women of IFA Network branches Mexico and Brazil. Thank you for joining us. Thank you for being here with us in this webinar that was a joint meeting as an effort to have also this connection and exchange knowledge with both countries and these great speakers. I'm very pleased of having you here, and thank you, because today we have a very interesting discussion, and the panelists that we had today were outstanding. So thank you, Ana Carolina, thank you, Jimena, thank you, Ana Claudia, Thank you, Stephanie. See you soon.
Thank you, Fabiola.
Thank
And
you so much
we
for the
want to
opportunity.
and we want to see everyone in the beautiful Cancun today. My background is an honor to IFA Cancun that we were supposed to have last year. Hopefully, we will have it soon.
Thank you, Ana Claudia. I think that everybody wants to be there right now. So you are very lucky of having at least that background. Have a nice day.
Thank you,
Bye-bye.
Thank
Bye.
you.
Thank you for your time,
Bye.
for the assistance.
Thank you to all
Bye.
participants. Bye.